Now we are going to start the session on investigation into affairs of the company. The thing is now, usually there are registrar of companies or central government or the shareholders who are the persons, who are the stakeholders who will be demanding the investigation into affairs of the company. In the case of registrar of company is there in every stage, minimum one registrar. There are certain states like even in Tamil Nadu, where there is registrar in Madurai as well as in Chennai, Pune and Mumbai in Maharashtra, and there are certain other states where there are more than one registrar. The purpose of the registrar of company is to receive the balance sheet, annual returns and all other accounts being filed in its offices as documents every year by every company registered under its jurisdiction. So every year all the registered companies are required mandatorily to hold annual general body meetings, file annual return, accounts, balance sheet, director's report and a host of other documents. Where on the scrutiny of any of these documents, the registrar of companies having any details required or any information or further explanation is required by him under the Companies Act, under section 206, he can issue a notice to such company requesting for further details. Then such officers who are involved in the affairs of the company ought to give such information and explanation. If such information and explanation is not issued by such companies, the registrar is having a very wide power to issue a summon to bring the documents before him so that he can examine the document and place his stamp on it, and he can place his marking by which he can keep the documents for some time by seizure if he wants. So what happens is, based on the information and explanation that is submitted to him, he can ask for information and explanation. Still, despite of this notice and summons, and despite of the information and explanation being called for, if the companies are not submitting the details, he can refer the matter to the central government for the matter being investigated by one or more inspectors to be appointed by the central government for that purpose. In this case, the Act very specifically provides that the central government may appoint one or more competent inspectors to investigate into the affairs of the company. In this section is very clear that it is a discretionary power of central government. That is why it is mentioned this company, the central government may, not shall. But in the cases where there is a resolution passed by, required number of shareholders or creditors or debenture holders or the persons who are interested in the affairs of the company, they pass a resolution that the affairs of the company ought to be investigated, and they make an application by a special resolution to the registrar. Then it will be communicated to the central government. Then the central government ought to appoint inspector or inspectors to conduct the inquiry into the affairs of the company. And when such informations and explanations are not procured, the central government has got power under section 209, where such information in his possession or otherwise, the registrar or inspector has reasonable ground to believe that books and papers of the company relating to the key managerial personnel or any director or auditor of a company has not been they can be likely to be destroyed or mutilated or altered or falsified or secreted, then the central government has power to seize such documents by way of entering into, with the assistance of such persons, which may be a collector or a police officer, and seize books and papers which he considers necessary for the purpose of implementing the provisions of the Act. He can also place marks on such records that is being taken by him. The maximum time he can keep the book is 182 days from the date of his seizure, which can be further extended to 182 days by a court's order. Instead of court, it can be by a tribunal also. And where the central government is of the opinion otherwise, that it is necessary to investigate into the affairs of the company, either on the report of the registrar or by passing of a special resolution by the shareholders or class of members I have already mentioned, or in public interest where there are cases that there are substantial manipulations involved, then they may approach a tribunal for an order for an investigation. When a tribunal in any proceedings make an order for investigation into the affairs of the company, the central government shall, it is mandatory on the part of central government to appoint such inspector or inspectors as the case may be. There are establishment of serious fraud investigation office under the government of India. The central government of India shall establish an office to be called serious fraud investigation office to investigate into the frauds relating to the company, and it may be directly or indirectly relating to banking, corporate affairs, taxation, forensic audit, capital market, information and technology, law, or any other such field that may be prescribed. Then the central government may by notification appoint a director in the serious frauds investigation office, who shall be an officer not below the rank of a joint secretary to the government of India, to investigate into the affairs of such financial companies or companies which have been already mentioned above. So, in addition to the normal investigation by the registrar of company by the central government, there is provision to investigate into the related companies companies affairs in other cases. That is, in other cases, whether the prescribed number of shareholders have resolved to constitute a company, or central government is of the opinion that affairs of the companies ought to be investigated, they can even investigate into the ownership of the company or into the affairs of a related company by appointing inspector or inspectors. The inspector or inspectors who are appointed by the central government under these provisions shall have the powers of a civil court under civil procedure code, and while they are enforcing attendance and taking evidence, they will have the power of a criminal court under criminal procedure code of the concerned matter. So the powers that is available to inspectors is very wide. They can enter into, search, seize, issue summons, take documents, make investigation into the affairs of the company, and do all the matters that is necessary to establish the credential and the true nature of the activities of the company. So the company can not only investigate into its own affairs, they can investigate into related affairs, related companies, and they can also investigate the affairs of the company in relation to this ownership, whether he is the true owner or the activities of the company is controlled by some other persons, which may be constituted as a benami transaction under Prevention of Money Laundering Act. So when such an activity is happening, it can be bound by some other act like the Prevention of Smuggling Act, MISA. So many other enactments are involved in dealing with such cases. So thus, this is a very important provision available under the Companies Act to investigate into the various affairs, to ensure justice and fairness to the investigators, creditors, members, and all interest groups involved in the company. And sometimes it also helps the directors and managing directors of the company to ensure fair and true policy. I think this is a very important activity as far as a company is concerned, and the central government has got more wide powers. I think with these words I conclude. Thank you very much.